Hey guys, welcome to Real Canadian Condo Disputes, where the condo drama gets real. Condo boards, condo rules, and real owner battles from across Canada. If you live in a condo, or you might one day, you need to hear these stories. Let's jump in.
All right, let's get into it. We're going to talk about a story that starts out so simple. A homeowner just wants a little more sunlight in their house, but it spirals into this multi-year, knockdown, drag-out court battle. It's really the ultimate cautionary tale for anyone living in a condo, and it all comes down to a single front door. I mean, it sounds kind of crazy, doesn't it? A front door? But this is a real case, and it perfectly illustrates that tension you find in any shared community. The answer, as you'll see, tells you everything you need to know about condo rules, why paperwork is so incredibly important, and what happens when a casual, informal okay goes horribly wrong. And right here, this is the core of the whole conflict. On one side, you've got an owner with a totally reasonable goal: swap out a solid door for one with glass panels to brighten up his home. Who wouldn't want that? But on the other side, you have the condo corporation, and their job, their legal duty really, is to enforce the rules and keep the look of the community uniform to protect everyone's property values. You can see how these two very legitimate goals were basically on a collision course.
Now, this whole thing didn't just blow up overnight. It was a slow burn. It all kicked off back in 2019 when the owner decided he wanted the new doors. He says he had a quick chat about it and then ordered them that August. But then, in 2020, here comes the game changer. A new, much more by-the-book property manager takes over. The doors don't even get installed until a year later in 2021, and by that point, the whole vibe around rule enforcement had completely changed.
And this is where it all gets messy. The owner's entire argument hinged on this one claim, that he got a verbal thumbs up from another resident, someone he believed was on the board. He said he was told, no worries, no paperwork needed. But that other resident, she was like, absolutely not. That conversation never happened. And by the way, I wasn't even on the board at that time. It's the classic he said, she said scenario, and with no paper trail, there was really nowhere to go but to the courts.
You know, the arrival of that new property manager in 2020 was really the spark that lit the fuse. Apparently, the old management was, let's just say, a bit more relaxed. Things were inconsistent. So when the new manager came in and started doing a proper review of the property, that's when these unapproved doors stuck out like a sore thumb. It just goes to show you how a simple change in who's managing the place can uncover some pretty big problems. So you might be wondering, why does the corporation get a say in someone's front door anyway? Well, it all boils down to this key legal term: exclusive use common element. It's a bit of a head-scratcher, I know. You think, it's my door. I'm the only one who uses it. And you're right, you do have exclusive use. But technically, in a condo, that door is owned by all the unit owners collectively. And that's what gives the corporation the authority to make rules about what it looks like.
Okay, so what was the right way to do this? Well, this slide shows you. It's not a quick chat in the driveway. It's a formal, three-step legal dance. First, you submit a written application. Second, you have to get written approval before you do anything. And third, you have to sign a formal agreement that gets registered on the property's title. This is all laid out in the Condominium Act. It's a whole different universe from the casual, verbal okay the owner thought he had.
To be fair, the corporation didn't just go from zero to a lawsuit. They actually tried to work this out. They told the owner, look, just apply for the doors now, after the fact, and we'll consider it. They tried to negotiate. They even offered to pay to replace his new doors with ones that followed the rules. They really made an effort to find a way out of this, and later on, the court took note of that.
But, none of it worked. The negotiations just fell apart. So by 2022, they were out of options, and the whole thing landed in court. The corporation filed to get a judge to force the owner to replace the doors, and the owner fired back with his own claim, saying the board was being oppressive and unfair. The battle lines were officially drawn.
And when the judge's decision finally came in, it wasn't even close. It was a clean sweep for the corporation. The court looked at the owner's claim about getting verbal approval and said, nope, we find that no approval, verbal or otherwise, was ever given. Then it looked at his claim that the board is being unfair and said, actually, the board acted reasonably and in good faith the whole time.
And this quote from the judge, this is the mic drop moment, it's so important. Basically, courts are very reluctant to step in and second-guess the decisions of a condo board that was elected by the residents. As long as that board is following the rules and acting in good faith, a judge isn't going to overrule them on stuff like property management or what the building should look like. It's a principle called judicial deference, and it's a massive shield for boards that do things by the book.
So the final court order was absolutely brutal for the owner.
First, the corporation got the green light to replace the doors. Second, the owner's entire case against them was thrown out. And then, to add insult to some very real financial injury, the court said the corporation could go after the owner to get its legal costs back. And you can bet those costs were not cheap.
Okay, so that's the story. A pretty rough ride for that one owner, for sure. But the real question is, what can the rest of us learn from this? For anyone who lives in or helps run a condo community, this is where you really want to pay attention. If you take away just one thing from this whole story, please let it be this. Section 98 of the Condominium Act is the golden rule. Any change you want to make to a common element, your door, your balcony, whatever, it requires written approval and a formal, registered agreement. A casual chat, a text message, a friendly nod, none of it counts. In the eyes of the law, a verbal promise here is worth absolutely nothing.
Look, trying to bend the rules or rely on informal agreements is just a massive gamble for everybody. If you're an owner, you could be forced to tear out your beautiful new renovation and get stuck with a giant legal bill. And if you're on the board, letting things slide here and there completely undermines your authority. It just invites other owners to challenge you down the road, and that leads to total chaos.
So, let's just boil it down. The big takeaways are pretty simple, but they are so important. For owners, get it in writing, always. For boards, you have to enforce the rules consistently for everyone, or they become meaningless. Remember, friendly conversations are for being good neighbors. They are not a substitute for the formal process. All this paperwork isn't just about being bureaucratic. It's about protecting every single person in the community from exactly this kind of expensive, stressful mess. And that kind of brings us to the final thought I want to leave you with. This entire disaster started with a simple misunderstanding of the rules. It really makes you think, doesn't it? Take a look at your own community. Are your rules and procedures crystal clear? Does everyone know how things are supposed to work? Or is there a potential door of discord in your community just waiting for someone to open it?
Thanks for watching Real Canadian Condo Disputes. If you found this breakdown useful, hit like, subscribe, and share your own condo experience in the comments.